The Supreme Court has just made a decision that could permanently reshape Social Security. A 9-0 ruling that almost no one is discussing. All 9 justices, with absolutely no disagreement, and every retired American across all 50 states is about to experience the consequences of what unfolded inside the nation's highest court. This is not a political narrative. It is not about left versus right. This was a unanimous judgment, which means both the most conservative and the most liberal justices came together, reviewed identical evidence, examined the same law, and reached complete agreement. That kind of unity is incredibly rare in a court that has been deeply divided for years. A 9-0 decision is not just uncommon, it is historic. And the fact that this has not reached your attention yet is exactly why you need to stay until the very end. What the Supreme Court has ruled directly affects the retirement stability of millions of Americans who spent decades working and contributing to a system they trusted would support them later in life. We are talking about Social Security benefits. We are talking about the income older Americans rely on every month to pay rent, buy food, afford medication, and maintain basic living conditions. And this ruling transforms the legal structure governing how that money is safeguarded, how it can be reduced, delayed, or denied, and what rights you now hold if the government interferes with what you are entitled to receive. Before this decision, there was a subtle but increasing trend within federal agencies that most retirees were completely unaware of. Administrative rulings regarding Social Security benefits were being made with little meaningful opportunity for everyday Americans to challenge them. The process was buried beneath layers of bureaucracy. Appeals moved slowly. Outcomes often seemed predetermined. Retirees who were wrongly denied benefits or saw their payments reduced without clear explanation found themselves stuck in a system that appeared designed to wear them down until they gave up. And many did give up. Because taking on a federal agency while living on a fixed income, when every dollar matters and legal costs can quickly drain savings, is not a fight most people can sustain. That was the reality before this ruling. Then came the case that changed everything. This is where one ordinary individual altered the situation for every retiree in the country. There was a man, a retiree who had worked for decades, paid into Social Security throughout his career, and reached retirement expecting to receive what he had been promised. Instead, the agency managing his benefits made a series of administrative decisions that reduced what he was owed. He challenged those decisions. He followed the official appeals process exactly as required. He obeyed every rule, submitted every form, met every deadline. Yet at every stage, the agency relied on its own interpretation of its own rules to rule against him. The system was essentially evaluating itself and always giving itself a perfect score. So he took the matter to federal court, and then higher courts, until it finally reached the Supreme Court of the United States. When the 9 justices reviewed what had happened, when they examined how federal agencies had been operating with nearly unchecked authority to interpret Social Security laws in ways that benefited the agency rather than the retiree, they did not split along expected lines. They did not divide ideologically. Instead, all 9 agreed completely. What the Supreme Court decided comes down to a principle that sounds simple but carries enormous weight. Federal agencies do not have the final say on what the law means when it comes to benefits you are legally entitled to receive. For decades, something known as the Chevron Doctrine gave agencies broad authority to interpret the laws they enforce. In practice, that meant when a Social Security law contained unclear language, the agency running the program could decide what that ambiguity meant. Courts were instructed to defer to that interpretation as long as it seemed reasonable, not necessarily correct or fair, just reasonable from the agency's perspective. Think about that. Imagine having a legal agreement where someone owes you money for life, But whenever there is a disagreement about the terms, that same person gets to decide what the contract means, and courts must accept their decision unless it is completely unreasonable. That was the system retirees were dealing with. The Supreme Court looked at that and said it cannot continue. Courts are supposed to interpret the law. That has always been their role. Now, when a federal agency makes a decision affecting a retiree's benefits and that decision is challenged, judges must apply independent legal analysis. They cannot simply approve the agency's interpretation. They must read the law themselves, determine its meaning, and protect the rights of the individual seeking what they were promised. That is the shift. That is what a 9-0 ruling looks like in real life. Why does this matter right now? If you are receiving Social Security, approaching retirement, or have a loved one depending on those payments, this is not some distant legal issue. This is the foundation of your financial security being rebuilt. One detail many discussions are missing is that the impact varies by state. Social Security involves federal rules, but also state-level processes in certain areas. Some states have been more aggressive in using administrative interpretations to limit benefits. Others have large backlogs of denied claims still in appeals. Those cases were decided under the old system where agencies had most of the interpretive power. Now they are being reconsidered under a completely different legal framework. In those states, many retirees may now have valid reasons to reopen cases or challenge past decisions. This does not guarantee every claim will be reversed, but it does reopen a door that had been closed for a long time, a door between Americans and the retirement security they earned. So which states are most affected? States with large retiree populations and high volumes of disputes, including Florida, Texas, California, Pennsylvania, Ohio, Michigan, Georgia, and Illinois. These states have seen tens of thousands of claims denied, reduced, or delayed. Many decisions were made by administrative judges within the Social Security Administration. Under the old framework, courts often deferred to those interpretations. That deference is now gone. Every pending and future challenge will be evaluated independently by judges determining what the law actually says. This is a major shift in power. Now consider the 3 benefit categories most impacted. First, Social Security disability insurance. Denial rates have been high, often due to how the agency interprets medical criteria. Courts previously deferred to those interpretations. Now they do not. Second, survivor benefits. Rules around eligibility, marriage duration, and coordination with other benefits were often interpreted by the agency. Courts can now independently review those interpretations. Third, retirement benefit calculations, including early claims, pension interactions, and mixed employment histories. These complex rules have led to interpretations that cost retirees significant amounts. Those interpretations can now be challenged more effectively. Looking ahead, this ruling also affects future decisions. It changes how agencies operate. Knowing their decisions can face real judicial scrutiny, officials are more likely to act carefully and fairly. This creates accountability not just legally, but institutionally. For someone planning retirement today, this means decisions about their benefits will be made under a system with stronger oversight. There are also misconceptions. Some people assume this ruling means benefits will be cut. That is not true. This decision does not reduce benefits or authorize cuts. It strengthens retirees' ability to challenge incorrect decisions. It shifts power toward independent courts. A common question is whether past cases can be reopened. The answer depends on timing and legal procedures. Deadlines still apply, but there may be limited pathways, especially with legal assistance. So what does 9-0 really mean? It means every justice-agreed agencies should not have unchecked authority over laws affecting your retirement. That unity sends a clear message. Courts will ensure the law is applied correctly. The bottom line is this: If you have paid into Social Security, this ruling matters. It strengthens the system's legal foundation. 9 justices, zero disagreement, all states affected. That is the story, and now you understand it. If this helped you learn something new, share it with others, leave a comment, and join the conversation.